That's okay. Okay. Thank you.
Just wanted to make sure.
Yeah. You can take what you. I'll be all right. All right, you may be seated. We'll give you 15 minutes, so let's come back at 3:05.
I think the most important thing is that the stain is out of my dress.
Now, I want to tell you, off the record. right, everyone ready?
Yes, ma'am.
All right, recalling the matter of the people versus, oh, we can just wait. We can just wait. I would call it one time. And you can sit until he tells them us all to rise.
I will stay standing, for I do not have to come down yet.
Okay, I understand. No worries, no worries.
I have the chance to just stretch my legs.
All right, for the jury.
All right, you may be seated.
Thank you, John.
Yeah, thank you. All right. And does it appear that all the jurors are back in their spaces? At this time, counsel for the city, jurors in their spaces?
Yes, Your Honor, we're ready to proceed at this time.
All right, what about you?
Yes, all jurors accounted for, Your Honor.
All right, do I need to recall this matter, Ms. Sandy, or are we still on the record? Okay, all right, you may proceed, counsel.
At this time, Your Honor, we will call the officer in charge, Officer Preston. Yes, to the stand.
Thank you. Ma'am.
Hi, thank you. She gave it to me earlier.
Okay, fantastic. So you're gonna come around this way. Officer, you raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes.
All right, you can put your hand down. Go ahead. It's not, so you're good. Just speak loudly. Just speak in that direction at all times, because I need the court reporter as well as the jurors to hear you.
Okay.
Okay, all right. You may proceed, counsel.
Good afternoon. Please state your name for the record.
Police officer Devin Curtis,
Now, where are you employed?
City of Detroit,
How long have you employed with the city of Detroit?
approaching 5 years.
Now, the date of this incident, which is February 4th, 2021, were you employed with the city of Detroit?
Yes.
How long have you been employed with the city of Detroit?
At that time, almost 2 years.
Okay, so let's go back a little bit. You've been sitting at this table next to me as the officer in charge. Explain to the jury what an officer in charge is.
The officer in charge handles court process of the case. Usually police officers on patrol are not the officer in charge of the case. However, there are circumstances where we are, for example, the tickets that we write.
On February 4th, 2021, 1:30 in the morning, the city of Detroit, state of Michigan, did you have a chance to encounter the defendant?
Yes.
And the defendant goes by the name of Felicia Wilson.
Correct.
And can you identify her today in this court? Is she in this court today?
Yes.
And can you point her out to the jury?
She's at the first chair, right, wearing the black leather jacket.
And did you have a partner at that time?
I did.
And what was your partner's name?
Police officer Glenn Vines.
Now, you heard the testimony of the officer as to the reason why the defendant was pulled over.
Correct.
Where was the scout car located at that time when you first observed the defendant?
We were on Alter Road, north of East Jefferson, approaching the intersection.
And can you please tell the jury to describe her driving at that time?
Ms. Wilson was traveling in front of us when we observed her disregard the traffic signal at East Jefferson and Alter.
And again, what was that traffic signal? What color was that traffic signal? What color was the light?
Red.
Was it a clear light or was she running through a yellow to a red?
No, it was a clear red.
And what happened next after you observed that?
My partner then initiated a traffic stop on Ms. Wilson's vehicle.
And what did you do at this time once there was a traffic stop? What did you do?
I approached the vehicle and stood at the passenger side of Ms. Wilson's vehicle.
Is there anything that you're doing as a passenger in the scout car, like with the computer? Is there a computer in the car?
Yes.
And are you doing anything with that computer?
During the traffic stop?
Yeah.
Yeah.
Okay, and what, tell the jury what, if anything, you're doing?
Typically, ideally, you would like to run the license plate before you initiate traffic, so you know what you're walking up to. And you also know if the vehicle is stolen or what have you. Or you can initiate traffic and verify all of that information after, which most people do.
And what did you do in this instance?
I guess.
Okay. At some point though, that night, did you run what's called a link?
Yes.
And explain to the jury what does a link stand for? What do those initials stand for?
LEAN stands for Law Enforcement Information Network. It's a system that we use to verify license plates, people's names, driving history, their address, weapon information, concealed pistol license, and numerous other things.
And at this time, did you find out something regarding the defendant's license?
Objection, relevance.
Response?
I have no objection, I can do one, Your Honor.
Okay, all right.
Regarding, did the link, you did a verification. The car was not stolen?
No.
What did you do after that, once you did your check? If you did at first?
I can't recall what order everything was done in, but then the investigation began on her driving behavior.
You got out of the car? And which side of the car of your vehicle, which side of her vehicle did you approach?
The passenger side.
Did you observe anything regarding the defendant?
The only thing that I observed was her response to, her physical response to my partner's questions.
And what did you observe regarding her physical response? Describe those physical responses.
The thing that was observed was her delayed reaction to the requested information, such as her license, registration, and insurance.
Did there come a time that night that you got to see her physical, any other physical attributes to her?
Yes.
And was that at the scene?
Yes.
And could you please describe what other physical observations?
After Ms. Wilson was asked to exit her vehicle, I observed her eyes to be glossy and red. I observed her to have slurred speech as we're communicating with her. And I observed her to be unsteady on her feet.
Based upon these observations, well, let me go back. We lay a foundation. In your history as a police officer, have you been trained to observe or to be able to identify a person who may be visibly impaired?
Yes.
And what are some of the factors that you've been trained to look at, to observe for visible impairment, just physical observation?
The exact observations I just stated.
And so you observed those that night regarding the defendant?
Correct.
To your knowledge, and if you can recall, do you recall her being aware of going through that red light?
Yes. No, let me correct that. She was not aware of the traffic light being red
Why do you say that?
because she stated she wasn't aware.
Now, you made a report. You were the report writer in this matter. You're the officer in charge, and you made a report regarding this. Is it common in writing a report to lay a foundation for you to put at the beginning that your body cam appears beyond and is functional?
Correct.
And why do you do that? What's the point of that?
For the purpose of going to court and, the body cams are played, during court, so it's important to know if they're.
Explain to the jury, if you have an opportunity to, have you been able to locate the body?
I myself, no.
Have you attempted to try to find the body? And explain to the jury the extent or the length that you went to try to find that body.
I'm actually on vacation right now, and I went into work to try to locate the body cam, and it was not able to be located.
Did you destroy the body cam?
No.
Did you destroy the dash?
No.
Have you ever observed a fatality?
Yes.
Objection, relevance.
Okay, I'll let you possibly I'll overrule the objection right now, but the foundation has to be very relevant to this particular matter as it proceeds and not exceed the guidelines of what's been laid today. Did she answer it?
No, I haven't even had, I'm.
Okay.
My wheels are turning.
Okay.
Have you ever seen a fatality disregarding a red light?
Objection, relevance.
What's the response?
Yes.
No, not response from you.
I think it is relevant, Your Honor, because stated, but for running a red light could possibly have caused injury and fatality.
That's
Response?
speculative.
It is. Now you can ask questions about her job, and the likelihood of her being able to see these things, but the connection back to this is not what's at hand today.
Okay, I'll withdraw.
Okay.
At some point that night, did the defendant tell you that she had been drinking?
Yes.
And again, did you take an oath?
I did.
Did you take an oath to protect yourself?
I did.
What does that oath mean to you?
It means to protect and safeguard lives and property and citizens of Detroit.
Do you take that oath seriously?
I do.
You have no further questions at this time.
Okay. Cross-examination?
Yes, Your Honor. Not so much. Sorry. I'd like to start with your training and background, if that's okay. So at the time of this incident, it was 2021. You said you'd been on the force for almost 2 years or close to 2 years, right?
Yes.
And what type of training had you gone through up into that point?
At that time, I had only received the standard training from the academy.
Okay, and as part of that academy training, did you go over how to write a police report?
Yes.
And part of that training, were you taught that police reports have to be accurate?
Yes.
Objective? Complete?
Yeah.
And truthful? And also with part of your training, you're taught how to preserve evidence.
Correct.
And also as part of the standard academy, do they go over standardized field sobriety tests?
They do.
And did you receive training in the field sobriety tests?
I did.
On your report, and this might be minute, but on the report, I have the location of the incident as 999 Alter Drive. Is that the address for the apartment complex, or is that, no, can you explain what that is then?
It's not an address that exists, but when you put in an intersection, which the offense occurred in an intersection, the computer automatically populates a number closest to that intersection. And East Jefferson addresses south are below 1,000, and then north of East Jefferson are 1,000.
Okay. There's some confusion for me. Thank you. So you said that this had occurred in an intersection, yes?
Correct.
Did you make the traffic stop in the intersection or in the parking lot of the apartment complex?
Not either.
Can you elaborate?
Yes. Traffic stops are rarely done in the intersection as it's not safe. So the offense was in the intersection, but we could cross through the intersection as she did. So the traffic stop was initiated just south of the intersection, parallel to a gas station.
And in your report, you say that her vehicle was legally parked.
Correct.
So how did it get legally parked if it was on?
So the parking for that apartment complex, I'm not sure if there's a parking lot behind it, but there's parking off of Alter, just behind that gas station that we were at. So there's cars parked on the street, not in the street, just off of the street. So when the traffic stop was initiated, she had already stopped her car right there to be parked. For the night.
City park for the night, right? So, thank
And part of, I want to go back to your training, and I don't mean to go back and forth. As part of your training, and I believe you testified to this on direct, you said that you were trained in signs of impairment, correct?
Correct.
And you still need probable cause to arrest someone or give someone a ticket for impaired driving, correct? Correct. And so is slurred speech enough probable cause by itself? Is glossy red eyes enough by itself?
No.
What about slurred speech and glossy eyes together? Is that enough?
Say for impairment, yes.
And when you approached the vehicle, you were on the passenger side.
Correct.
And you had testified on direct that you could observe her physical signs. Correct. Could you hear anything?
Not that I can recall.
So, did Ms. Wilson make any statements to you about whether she had consumed intoxicants?
Yes.
And if she did, why isn't that in your report?
I can't recall.
But
It's only in the search warrant for her license.
And so that is not being brought in today, so we are just dealing with the report. And you had testified that your reports must be complete and accurate, correct? If, then your report would not be complete or accurate if it's missing her statements.
That could be corrected.
And then you said that you tried to locate the body cam, correct? Correct. And you also testified that the purpose of those body cams is for court. For incidences such as this, or a trial.
That's one of the reasons we have them, yeah.
Okay. Just trying to be a little bit more narrow. So is there a way to inform a superior that a body cam may need to be preserved?
If there is, I don't know.
And you had testified earlier that you have a duty to preserve evidence.
Correct.
But yet you cannot find the body cam from the stop.
Objection, Your Honor. I believe that testifying that that's not her job. I think that that's not his goal. And I object to relevance of that.
Response?
Your Honor, she had testified that she attempted to locate the body camera, and so I'm just following up on that question.
She did.
Preserving and attempting to follow is not the same.
I agree that preserving and attempting to follow are not the same, but you can ask her, is it her responsibility to preserve it? I'll allow for that question to be asked.
I'll go with that question. Is it your duty to preserve it?
And I'm willing to give a little extra information on that process if you need that.
Sure.
So,
Is there a question before?
I was about to say, you gotta wait until there's a question, okay?
Great. I guess I should elaborate. Sure, if it is asked. Thank you. The last thing that I'd like to discuss with you, Officer Furness, is you said that you were trained on field sobriety tests, correct? And what is your understanding of field sobriety tests?
field sobriety testing are to be conducted to determine whether a person is intoxicated or not.
And why did you choose not to perform field sobriety tests in this instance?
Due to the incident being 3 years ago, I can't recall. But there are instances where we are advised not to.
Do you recall if this was one of those instances?
I can't.
As part of your training on those field sobriety tests, you're taught that the field sobriety tests, specifically if you use the horizontal gaze nystagmus, the walk and turn, and the leg stand, have a scientific.
Judge, I'm gonna object because she's testifying, she's acting as the expert in explaining it. That has not been explained. Those terms have not been mentioned. Acting as the expert.
I do. You have to establish some faces. You can ask her about those, but just to say those tests, establish and ask, is she familiar with any of these tests? And I would take it one by one too.
And I can do that, Your Honor. She
Okay.
did testify that she had been trained in these, and so I'm following up on that training, and that would have been a part of that standard training.
But Your Honor, I'm saying that she has to lay a foundation.
Right,
You haven't laid
right.
a
So
foundation.
I just want to caution both of you to remember that the testimony from your mouth is not what they'll end up hearing. They'll end up considering the evidence that comes from the witness's mouth. So you want to make sure you establish and let them testify to their knowledge and their understanding. So I will rephrase that question. Note your objection. I'm going to sustain it, and I'm going to say you got to rephrase this question to something else, okay?
No problem, Your Honor. As part of your field sobriety test training, what are you taught?
We are taught to administer 3 separate tests.
And what are those three separate tests?
The nystagmus, the one leg stand, and the walking turn test.
And are you taught anything about those three tests together?
Those three tests together, you don't have to do all three, you can do two, but two minimum have to be completed. But you are to complete those tests to determine if someone's intoxicated or not.
No further questions, Your Honor.
All right. Any redirect based on that question?
Yes, Your Honor.
Okay.
Officer Furness, we are here for the charge of operating while visibly impaired. Is that correct?
Correct.
Is that your knowledge?
Yes.
Is that your understanding?
Yes.
And so do you need the standard field sobriety test to see if a person is visibly impaired?
I do not.
Okay, what do you need to establish as an officer visibly impaired?
Observations. Observations.
Thank you. I have no further questions.
All right. Based on the questions that have been provided, jurors, if you have any questions, please write them down at this time and hand them to our officer. If you have no questions, that's okay as well. All right. Counselors, could you please approach? Officer, I have two questions for you. The first one is, what were the three tests? They couldn't hear you, so please say the test again,
Okay.
as big as you
The
can.
first one is the nystagmus, which is a test on your eyes. The second is a walk and turn test. And the third is a one leg stand.
All right. And then the other question is, was the stop in the gas station or on the street next to it?
On the street next to it.
And then, to answer the other part, you will have the opportunity to talk about this in the jury room, okay, everyone? All right. Any questions based on those questions asked by the jury?
None for me, Your Honor.
Okay, what about?
None from defense, Your
All
Honor.
right. May this witness be excused?
Yes.
All right, you may be excused now, back to the table. Are there any more witnesses for the people at this time?
May I confer with my,
You may.
no other witnesses, Your Honor.
What about, so at this point, do you have any evidence that you need to put into the record, or are we all set?
We're all set, Your Honor.
All right, do the people rest?
We would rest, Your Honor.
Thank you. Now, defense counsel?
Yes, Your Honor, defense would also rest.
Okay, do I need to voir dire your client outside the jury or no? Okay, all right, all right. All right, with that being said, are we ready to move to the closing arguments, or do each side need a little bit of time? Okay, the jurors, do any of you need to stand up and stretch, or are you good to hear closing arguments? You need to stand up and stretch. Go ahead, stretch if you need to.
I'm good.
Oh, you good? Okay.
Yeah, it's stressing.
Fantastic. All right. Well, if we are ready to go, closing arguments for the people.
Well, this was a short one, ladies and gentlemen. I started with that theme, the choices, and I'm gonna end with the choices. There's been a lot of talk about the standard field sobriety test. You didn't hear from anybody but the officers. The standard field sobriety tests are not mandated. This is visibly impaired. They can look at a person based upon the training that they've got, and they can make that determination. If they want to go to a higher charge, a more serious charge, yeah, then maybe we need to be talking about standard field sobriety tests. But for the operating while visibly impaired, that's the whole point, visibly impaired. I can look at you, and based on my experience and my training, I can look at you and tell there's something that's not right. Now, when you have somebody that's sitting up there, first of all, they admit to you that they're drinking. You had nothing to uncover. There was nothing to dispute that. She admitted that she was drinking. You have a person who's sitting up here, they didn't even realize they didn't even realize that. We know the serious consequences of that. Those are things that really add up in the totality of the circumstances. And she was visibly impaired that night. The glassy eyes, the slurry speech, the hey, I had a couple of drinks. Those are things that clearly indicate that she was visibly impaired. She was not able to do what? Let's go back to this. She was not able to do this. The defendant drove with less ability than what an ordinary careful driver. The defendant's ability to drive must have been lessened to the point that it would have been noticed by another. It was noticed by the officers, and her ability was lessened. You heard about buzz driving. You can think that you're okay, but your reflexes are not that good. Again, let's go back to I didn't even know that I ran the red light. Okay? I didn't even know that. That's serious. All of these factors have been met beyond a reasonable doubt. She was operating a motor vehicle. You heard that testimony. Operated on a public street. You know that all drink Jefferson. And the third, due to the consumption of the alcohol, even her admission, well, nothing else. She admitted that she was drinking. And then you put together that with the glassy eyes and the slurred speech, what do you have? That beyond a reasonable doubt was operating the vehicle while visibly impaired. The defendant made choices that night. And there might have been some circumstances for her drinking. There might have been some circumstances in her life that were not great. But to put others in jeopardy, including herself, that's not fair. That's not a smart choice. That's not a good choice. Or the officers take it on to protect and to serve. And part of that is to protect and to serve the defendant. They don't have anything to gain by this. They have nothing to gain by pulling her over. These stops are long. It takes them out of service for a while. They got to do paperwork. You got to do mounds of paperwork with this. This isn't fun. But in order to stop somebody from doing something that could possibly lead to serious harm to herself and to others, it's worth it. And this is the oath they take to protect and to serve, to make sure that something worse didn't happen. No matter what verdict you come back with today, I'm gonna say this, and I thought about this. I thought about this at home. I said, should I say this? What verdict? You come back to me. I don't care what it is. I'm gonna say it. We've won. Because you know what? We got somebody off the street that could have been a danger to somebody else. We could have possibly have saved the defendant or somebody else from serious harm or property damage. So we have won. No matter what your verdict is, we won. But I believe that we have shown this case beyond a reasonable doubt, common sense, that she was operating while visibly impaired. Thank you for your time and attention. I appreciate it.
Closing argument for the defense.
Thank you, Your Honor.
You're welcome.
You just heard the prosecutor talk about what if, could have, and should have. Could have saved somebody. Maybe did. None of that happened here. What did happen here, and what you heard today, is that the prosecutor could not prove their case beyond a reasonable doubt. If you take a look at the jury instruction, the full jury instruction that you guys will be given, it says that drinking of alcohol, use or consumption of a controlled substance, use or consumption of an intoxicating substance, ladies and gentlemen. You heard Officer Furnace say that the standardized field sobriety test can absolutely help in proving somebody was intoxicated. You know that the influence of alcohol is considered intoxication. So officers here made a choice. They made a choice to not do a full investigation. You also heard both officers say, specifically, Officer Vines, say that red, glassy eyes is not enough for probable cause. Also, a slurred speech is not enough for probable cause. And he even said together that's not enough for a finding of intoxication. Officers made the choice to go off very little evidence and charge Ms. Wilson with a drinking and driving offense. You also heard that there's inconsistencies between the report and the testimony today. The only thing that says that Ms. Wilson, consumed an alcoholic beverage is from what Officer Furnace testified. But yet it's not in her report. She told you guys that her report is supposed to be truthful, accurate, and complete. That is not complete, ladies and gentlemen. Also, you were told that the body camera specifically used for the purposes of court and can help in purposes of court. Now, while these officers may not have to go through the preservation process, they do have a duty to preserve evidence. They're taught that. Yet the evidence wasn't preserved in this case. That evidence could also be used to help Ms. Wilson, but we don't have it. So what are we left with today? We're left with the testimony. We're left with your jury instructions that you guys have to make a choice on. I firmly believe that there has not been beyond a reasonable doubt that Ms. Wilson was impaired. The delayed reactions that Officer Vines testified to, he didn't say how delayed they were. He didn't testify that they were abnormal. Only Officer Furnace. If Officer Furnace and Officer Vines were so in tune with this case, so in tune that she was intoxicated, why doesn't everything match up? Why are there inconsistencies? These inconsistencies, ladies and gentlemen, is reasonable doubt. And if you have even a shred of reasonable doubt, Ms. Wilson is not guilty. We ask that you find not guilty today. Thank you.
Counsel, since it's your burden of proof, you have the last opportunity if you would like. I'm gonna just print, give me 1 second, I gotta print this out.
We're in a age today, ladies and gentlemen. Every time you turn around, everywhere you go. I was this kind of came to me a few weeks ago. A friend of mine went to a concert. It was a great concert. She came back and told us how great the concert was. She didn't have this picture. Concert. Because the artist took all the phones away. Okay? So am I supposed to believe that my friend didn't go to a concert because she didn't have pictures to prove it to me? Are we gonna get into a day and age where now testimony should be forgotten? So why are we here today? Why don't we just put on video and just leave it at that? Because the video would just tell us everything. Well, what happened is the video wouldn't even, first of all, show you every single thing that would happen. When you heard the testimony of these officers, they were straight up for it. They don't know what happened to the body cam. Their thing is, they put their stuff on and activate, they put it back, and they preserve it. That's what they do. They put it back into the little station cradle, and then that's what they do. That's what they do. There's probably some tech guy out there in the big land or whatever that does something else with it, but that's not their job. There's these inconsistencies. Oh, does that sound like a great conspiracy, the great lie? If they're trying to lie, if they're trying to cover up, would have been a really nice report. She wouldn't have put at the beginning of her report, body cam activated and lowered. Why put that there? They're trying to hide something. Yeah, it's not a perfect report, but people aren't perfect. And if you were gonna lie, if you're trying to do that, you just put all of those nice little goodies in there. Yeah, there was something else that was where, that she wrote this information down. You can't talk about it. But she did write it down. She did make the observation. She did document it. She did document it. She just wasn't documenting this one. So again, I tell you that just because the body cam wasn't available doesn't mean that this didn't happen. Just because you weren't able to film the concert doesn't mean you didn't go. You were still there. Just because you didn't, videotape mom, the family reunion, doesn't mean that you didn't go. Okay? You were still there. So again, I ask because elements have been met, now that we've done, that you come back with a verdict of guilt. Okay?
Members of the jury, the evidence and arguments in this case are finished, and I will now instruct you on the law. That is, I will explain the law that applies to this case. Remember that you have taken an oath to return a true and just verdict based only on the evidence and my instructions on the law. You must not let sympathy, bias, or prejudice influence your decision. You must avoid reaching conclusions that may have been unintentionally influenced by stereotypes. You must reach your own conclusion about this case individually, but you should do so only after listening to and considering the opinions of other jurors who may have different backgrounds and perspectives from yours. As jurors, you must decide what the facts of this case are. That is your job and nobody else's. You must think about all the evidence and then decide what each piece of evidence means and how important you think it is. This includes whether you believe what each of the witnesses said. What you decide about any fact in this case is final. It is my duty to instruct you on the law. You must take the law as I give it to you. If a lawyer says anything or something different about the law, follow what I say. At various times, I have already given you some instructions about the law. You must take all my instructions together as the law you are to follow. You should not pay attention to some instructions and ignore others. To sum up, it is your job to decide what the facts of this case are, to apply the law as I give it to you, and in that way, decide the case. Person accused of a crime is presumed innocent. That means you must start with the presumption that the defendant is innocent. The presumption continues throughout the trial and entitles the defendant to a verdict of not guilty unless you are satisfied beyond a reasonable doubt that she is guilty. Every crime is made up of parts called elements. The city must prove each element of the crime beyond a reasonable doubt. The defendant is not required to prove her innocence or do anything. If you find that the city has not proven every element beyond a reasonable doubt, then you must find the defendant not guilty. A reasonable doubt is a fair and honest doubt growing out of evidence or lack of evidence. It is not merely an imaginary or possible doubt, but a doubt based on reason and common sense. A reasonable doubt is just that, a doubt that is reasonable after careful and considered examination of the facts and circumstances of this case. Every defendant has the absolute right not to testify. When you decide the case, you must not consider that fact that she did not testify. It must not affect your verdict in any way. When you discuss the case and decide on your verdict, you may only consider the evidence that has been properly admitted in this case. Therefore, if it is important for you to understand what is evidence and what is not evidence. Evidence includes only the sworn testimony of witnesses. Many things are not evidence, and you must be careful not to consider them as such. I will now describe some things that are not evidence. The fact that the defendant is charged with the crime and is on trial is not evidence. Likewise, the fact that she is charged, strike that last part. The lawyer's statement and arguments are not evidence. They are only meant to help you understand the evidence in each side's legal theories. You should only accept things the lawyers say that are supported by evidence or by your own common sense and general knowledge. The lawyer's questions to the witnesses, your questions to the witnesses as well, and my questions to the witnesses are also not evidence. You should not consider these questions, you should only consider these questions as they give meaning to what the witness's response was. My comments, rulings, questions, and instructions are also not evidence. It is my duty to see that the trial is conducted in accordance to the law and to tell you the law that applies in this case. However, when I make a comment or give an instruction, I'm not trying to influence your vote or express a personal opinion about the case. If you believe I have an opinion about how you should decide this case, you must pay no attention to that opinion. You are the only judges of the facts, and you should decide this case from the evidence. At times during the trial, I have not excluded evidence, but I could exclude evidence. But you heard sometimes rulings on different objections that were made. Do not consider those things in deciding this case. Make your decision only on the evidence and let in and nothing else. Your decision should be based on all the evidence, regardless of which party produced it. You should use your own common sense and general knowledge in weighing and judging the evidence, but you should not use any personal knowledge you may have about the place, person, or event. To repeat once more, you must decide this case based only on the evidence admitted during this trial. As said before, it is your job to decide what the facts of this case are. You must decide which witnesses you believe and how important you think their testimony is. You do not have to accept or reject everything a witness said. You are free to believe all, none, or part of any person's testimony. In deciding which testimony you believe, you should rely on your own common sense and everyday experience. However, in deciding whether you believe a person's testimony, you must set aside any biases or prejudice you may have based on a witness's disability, race, national origin or ethnicity, gender identity or sexual orientation, or religion, age, or socioeconomic status. Again, take the time you need to test what might be automatic or instructive judgment and to reflect carefully about the evidence. There is no fixed set of rules for judging whether you believe a witness, but it may help you to think about these questions. Was the witness able to see or hear clearly? How long was the witness watching or listening? Was anything else going on that might have distracted the witness? Did the witness seem to have a good memory? How did the witness look and act while testifying? Did the witness seem to be making an honest effort to tell the truth? Or did the witness seem to evade the questions or argue with the lawyers? Does the witness's age or maturity affect how you judge his or her testimony? Does the witness have any biases, prejudice, or personal interest in how this case is decided? Have there been any promises, threats, suggestions, or other influences that affect how the witness testified? In general, does the witness have any special reason to tell the truth or any special reason to lie? All in all, how reasonable does the witness's testimony seem when you think about all the other evidence in the case? Sometimes the testimony of different witnesses will not agree, and you must decide which testimony you accept. You should think about whether the disagreement involves something important or not, and whether you think someone is lying or is simply mistaken. People see and hear things differently, and witnesses may testify honestly but simply be wrong about what they thought they saw or remembered. It is a good idea to think about which testimony agrees best with the other evidence in this case. However, you may conclude that a witness deliberately lied about something that is important to how you decide this case. If so, you may choose not to accept anything that witness said. On the other hand, if you think that the witness lied about something but told the truth about others, you may simply accept the part you think is true and ignore the rest. Prosecutor must also prove beyond a reasonable doubt that the crime occurred on or about February 4th of 2021 in the city of Detroit. When you go to the jury room, you will be provided with a written copy of the final jury instructions. I'm just going to send in the elements of the crime if that's okay with both parties. Okay, I'll send you in with the elements of the crime. If you need further clarity, let me know. You should first choose a foreperson. Okay, and see that this foreperson is going to see that your discussions are carried on in a business-like way and that everyone has a fair chance to be heard. During your deliberations, please turn off your cell phones or other communication equipment until we recess. A verdict in a criminal case must be unanimous. In order to return a verdict, it is necessary that each of you agree on the verdict. In the jury room, you will discuss the case among yourself, but ultimately, each of you will have to make up your own mind. Any verdict must represent the individual considered judgment of each juror. It is your duty as jurors to talk to each other and to make every reasonable effort to reach an agreement. Express your opinions and the reasons for them, but keep an open mind as you listen to your fellow jurors. Rethink your opinions and do not hesitate to change your mind if you decide you were wrong. Try your best to work out your differences. However, although you should try to reach an agreement, none of you should give up your honest opinion about the case just because other jurors disagree with you or just for the sake of reaching a verdict. In the end, your vote must be your own, and you must vote honestly and in good conscience. All right, if you have any questions about the jury instructions before you begin deliberation or question about the instructions that arise during deliberation, you may submit them in writing in a sealed envelope to the bailiff. What I'll have you do is I'll present them with a notepad that's blank. If you have any questions during it, you're going to knock on the door. One of the bailiffs will be outside and they'll be able to hear. They'll bring the note in the courtroom and we'll bring you back in here to answer. When you do reach a verdict, if you do reach a verdict today, you're going to simply put that you have reached a verdict on the sheet of paper, the foreperson, and you're going to give it to the deputy. Once you come back, the foreperson will give it to the deputy. They'll hand it to me and I'll be able to read it. And we'll have hand it back to you for the reading out loud of the verdict, okay? Members of the jury. Possible penalty should not influence your decision. If you find that defendant guilty, it is the duty of the judge, that's me, to fix the penalty within the limits provided by the law. If you want to communicate with me while you're in the jury room, please have your foreperson write a note and give it to the bailiff. It is not proper for you to talk directly with the judge, lawyers, court officers, or other people involved in this case. As you discuss this case, you must not let anyone, even me, know how your voting stands. Therefore, until you return with a unanimous verdict, do not reveal this to anyone outside of the jury room. When you go to the jury room to deliberate, you may take those notes that you took, as well as a copy of the what I'll provide for you as far as the elements of the crime. If you want to look at any of that information, be my guest. When you go to the jury room, you will be given a written copy of the elements of the crime, so that you'll be able to discuss it with the fellow jurors at that point in time. I prepared a verdict form, and I don't know if either one of you did. At the top, it has the defendant's name. It also has this case number. It says you may return only one verdict on this charge. Mark only one box on this sheet. The first one says not guilty. The second one says guilty of operating while visibly impaired. Underneath, it says the foreperson. You just have to put your signature and date it on there. The prosecution has introduced evidence of a statement that it claims the defendant made. Before you can consider such an out-of-court statement against the defendant, you must first find that the defendant actually made the statement as given to you. If you find that the defendant did not make the statement, you may give the statement whatever weight you think it deserves. In deciding this, you should think about how and when the statement was made and about all of the other evidence in this case. You may consider the statement in deciding the facts of this case. Facts can be provided by direct evidence from a witness or an exhibit. Direct evidence is evidence about what we actually see or hear. For example, if you look outside and see the rain is falling, that is direct evidence that it's raining. Facts can also be provided by indirect or circumstantial evidence. Circumstantial evidence is evidence that normally or reasonably leads to other facts. So, for example, if you see a person come from outside wearing a raincoat covered with small droplets of water, that will be circumstantial evidence that it's raining. You may consider circumstantial evidence. Circumstantial evidence by itself or a combination of circumstantial evidence and direct evidence can be used to prove the elements of a crime. In other words, you should consider all evidence that you believe you should. You have heard testimony from police officer witnesses. This testimony is to be judged by the same standards you use to evaluate the testimony of other witnesses. Okay. Counsel for the city, have I missed any instructions that you would like me to give at this point in time?
No, Your Honor, we're satisfied.
All right, counsel for defendant.
Your Honor, may we approach?
Yes, you may.
briefly?
After I finish, okay. All right, I just want to reiterate too that the closing arguments that defense counsel as well as the city attorney both gave, those are just to guide you. Remember, that's not evidence, it's just to guide you in the process of arguing their cases and how they see it at that particular time. So please remember that those matters are not actually evidence, it's just to guide you. You are to reflect back on the evidence and testimony that you heard from the bench and whether or not it matches with the closing arguments that were made, okay? All right. At this point in time, I'm going to have the clerk swear in both of the deputies.
You gonna stand up?
Yeah, they're good.
Oh,
Just the deputies now.
please raise your right hand. You do solemnly swear that you will, to the utmost of your ability, keep the persons sworn as jurors on this trial until they shall be discharged, and that you will not, before they render their verdict, communicate to any person the state of their deliberations or the verdict they have agreed upon, to help you God.
Thank you. All right, at this time, I'm going to have the officers take you. I will give you the verdict form. I'm going to let you go into the room. I'm going to give you, we have to close the court soon, but I'm going to hope that we can go at least until 5 today, if that's okay with everyone. We'll go until 5 today to give you some time. I do want, but if you need additional time, do not feel rushed. As I stated, we can always come back tomorrow, but we're going to give you, they'll come up with the verdict form as well as those instructions that I said I will hand back to you. So. All right, go. All right, you good. All right, so you know how to keep them in form and course. So you know how to keep them in form and course.
Yes.
Okay. All right, fantastic. All right, we follow your instructions now. All right, for the jury. I'm gonna give her a copy of the instructions. All right, they may be seated, yes. All right, I'm gonna let y'all look at the, thank you, before I send it back to them. I did that. So it was closed, right? I said it was closed, right? Let them look at it too, at the tables. So it's closed, isn't it? Yeah, just look, I think it's extra words I may have to take out of that I didn't give to them at the end of it, but let me know.
Would not. Attorney Miller scratches off all the.
I would
not-
never, I would
Would not
never.
in front of them. Every night.
Should be aware of that.
Every shape, every.
I mean, I'm gonna tell them. I don't know why. They thought it was a part of this today.
No, but just for fun.
Oh, I'm sorry, were we on the regular?
No,
Just more so stating, like, I'm good with it.
it's okay, Sandy, no, I'm just,
But you're kind enough to prepare those for us, so.
then I have another. Okay, all right. Now those can be rendered over to them. I'll give everybody a break, at least to get themselves together for a moment and then. If they do, yes, I was gonna say, you just gotta come back if I need you.
Yeah. Did you want to envelope for them to be able to get verdict?
No, just have them fold it over when they have it. You can communicate that to them. Just have them fold it over. The note first, though, just saying.
Animatopia. I think it's somebody. Animatopia. Animatopia.
I think I have, this is kind of English grammatical, that's a grammatical thing.
It's like when a person says.
Oh, yeah, you gotta type out like EEERRRKKKKK.
But I put in there onomatopoeia. That means that you're making a sound or whatever.
Really?